Hello, everyone. Welcome to today's webinar in our series on AI-driven innovation in medical technologies. Today, we'll be presenting on the topic of patent litigation and enforcement with an emphasis on AI and medical-related technologies. This is the fourth episode in our webinar series. We invite you to access our website or YouTube channel to watch the previous presentations in this series on patent landscape trends, patent eligibility challenges, and licensing and monetization. A quick note that we'll be recording today's webinar and sending a link to the recording and slides to everyone who has registered. We'll also put a link in the chat to access the presentation slides online. My name is Robert Herning, and I'll be your moderator today. I'm a patent attorney and a principal at SLW, and my practice involves patent preparation and prosecution in a variety of technology areas, including medical devices and related medtech software. During today's presentation, I'll be monitoring the webinar session for questions from the audience. If you'd like to ask a question, you can enter your questions using the Q&A feature in the Zoom menu or in the chat. We'll address the questions either during the presentation or at the end, time permitting. Our guest speakers will be Emily Niles and Prateek Viswanathan from Robins Kaplan LLP in Minneapolis. Emily is a partner and registered patent attorney at Robins Kaplan. She has extensive experience litigating patent infringement matters involving complex technologies, including medical devices, software, and other innovations, and handling litigation and disputes involving trade secrets and technology licensing. She's the co-chair of Robins Artificial Intelligence Committee. Prateek is an associate at Robins Kaplan. He focuses his practice on complex intellectual property litigation and patent disputes involving emerging technologies. His background is in biomedical engineering, and he has worked on a variety of matters involving medical devices, computer algorithms, and financial technologies. We're looking forward to hearing more on this litigation topic today. So thank you so much, Emily and Prateek, for joining us. And with that, I'll hand the presentation over to you.
Thanks so much.
Thank you.
All right. To kick things off, we're excited to share some updates today on the patent enforcement front in terms of some medtech cases and some updates on how AI is coming up in those cases. And Prateek and I are excited to share those updates with you today. So a bit of an agenda. We're going to start out with some litigation activity in consumer medical devices. We're going to talk about some updates in patent eligibility cases and findings related to AI and machine learning. And then we're going to move on to some challenges to the novelty of medical device patents involving AI. We're going to talk about then we're going to move into some kind of practical implications of AI in litigation. We're going to talk about some decisions and examples of things happening in discovery during litigation involving training set data, and also some cases involving AI utilization by expert witnesses. So we're excited to be here today and discuss these topics with you and give you some takeaways from some significant enforcement cases. So to kick things off, let's move to litigation activity in some consumer medical devices. We're going to cover some updates on some litigation from some devices you are probably pretty familiar with. We'll start out with some litigation involving Apple Watches, and then we'll talk about the Oura Ring litigations as well. Prateek, do you want to give us an update on the Massimo case?
Absolutely. Thank you for your time. So, as you may know, Massimo and Apple have been litigating over the Apple Watch infringement of several Massimo patents across multiple forums for years. In particular, here we have the district court case from the Central District of California that reached a jury verdict in November of 2025. So in that district court proceeding, Massimo ended up claiming that Apple infringed on the 776 patent, specifically claims 11, 12, 13, and 14. As you see here, the claim 11 preamble recites a patient monitor configured to monitor at least the pulse rate of a patient by processing signals responsive to light attenuated by body tissue. The patient monitor comprising several limitations. These claims were directed to two distinct control protocols, each of which use different light sources to calculate pulse rate and other values. And then they also recited that the patient monitor switches between these two duty cycles based on some physiological measurement that it receives. They don't, however, cite any process for notifying the user of the measurement, and that will be a key fact later. But ultimately, the the key issue here in the infringement dispute focused on whether the Apple Watch was a patient monitor or not. Apple argued that it was not a patient monitor because the Apple Watch did not notify the patient reliably enough to be a monitor. The accused features in Apple's telling were that it was a high/low heart rate notification system and that it was not reliable. The notification did not measure the heart rate during the motion. They were unavailable for significant periods of time, and they weren't even accessible. Massimo, in contrast, however, did argue that a patient monitor is a device that measures heart rate. The claims in Massimo's tell define the patient monitor by its function, as in something configured to measure the heart rate. And then Massimo noted that the claims did not require any sort of display or notification, and instead just covered the electrical circuit that switches duty cycles. And then Massimo ended up prevailing because they could point to several witnesses and Apple witnesses who admitted that the Apple Watch was a heart rate monitor. Ultimately, the jury verdict sided with Massimo to the tune of $634 million and more. So why is it interesting? One particular reason this case is interesting to us is the nature of the preamble. Preamble here being a patient monitor before the jury. And no matter whether it's limited or not, it's a plain and ordinary term that a jury can very well apply its own biases and understanding to, since the patient monitor terms are a little more understandable and plain than other medical device terminology or other patent terminology. So one thing worth considering is how having a jury-friendly preamble or jury-friendly terms may aid in enforcement of the patents if it helps the jury understand their invention that much better. So that's the jury verdict. So that can bring us to the next slide, which will be talking about more updates in the ITC forum from early March. So for context, earlier the ITC, the International Trade Commission, issued an exclusion order against the Apple Watch. After that, Apple redesigned its watch, and then the ITC had to hear litigation on the redesign as well. The first of two orders that we're discussing is the Federal Circuit upholding the ITC's exclusion order against the original Apple Watch. That's what we have here. Basically, the ITC found that Massimo had established a domestic industry and then it's decided to exclude the original Apple Watch because it found it was infringing. The Federal Circuit affirmed that decision. Note here the asserted claim in the ITC focused on what's called a user-worn device configured to non-invasively measure an oxygen saturation of the user, which comprises several limitations going forward. This user-worn device preamble term features heavily in both this and the next order. Here, for purposes of the domestic industry, Massimo had to argue that some of his prototypes were user-worn devices because they were capable of using a strap to be attached to the user. And that definition of user-worn device would later be hotly contested and a key issue in the next order. If we can have next slide, please. Thank you. So in the next order, the ITC had to consider Apple Watch's redesign, the redesign of the Apple Watch, and ultimately it ruled that the redesigned Apple Watch did not infringe on the same claim that the Federal Circuit had already discussed due to its construction of the user-worn limitation. For context on the redesign, Apple introduced a redesigned blood oxygen technology for the Apple Watch, starting with Series 9, Series 10, and the Ultra 2 models, and it did so via a software update. In the original version of the Apple Watch, the readings were collected from the watch's blood oxygen sensors and originally displayed on the user's watch. But in the designer round, it would merely collect the readings from the watch's blood oxygen sensors, but then process and display them on the paired iPhone instead. So that brings us to the legal issue at the heart of the infringement case, which is, what is a user-worn device? Next slide, please. Massimo contended that the plain and ordinary meaning of user-worn device meant a device that was born or carried on the person. Apple, on the other hand, claimed that user-worn device meant a device that was configured to be worn on the user. Ultimately, the ITC agreed with Apple in this case that it was configured to be worn on the user for several reasons on the slide. Most importantly, the specification of the asserted patents did not use the specific term user worn outside of the claim language, but it did especially distinguish between embodiments that were handheld or portable and embodiments that can be attached to the patient. For example, there was an embodiment where the monitoring device is handheld and the figure associated with it looks like a phone. And then conversely, there was an embodiment where the monitoring device includes a finger clip sensor that can be attached to the patient. So clear evidence that the specification itself distinguished between handhelds and devices that were worn. The other most important finding here is that the ITC referred back to Massimo's argument for the domestic industry in the previous order we just discussed, where Massimo asserted that some of his prototypes were user-worn devices and therefore established a domestic industry because they included ways to add and use a strap for the user. So ultimately, due to this claim construction dispute, the ITC found that the redesigned Apple Watch did not practice the inventions and did not infringe. The key takeaway here, what makes this interesting to me, is that Massimo ended up being put in an awkward position in the middle of the litigation after Apple released its redesign, because the redesign split the invention across both the wearable form factor and the handheld form factor. Massimo would have honestly been better off had it had claims and spec support covering processes split between both form factors. And going forward, having a claim set that can cover this kind of split between multiple form factors would be helpful. Now, with that, I think we can move on to the OTC investigations.
That sounds great. It sounds like one of those takeaways was being sure to have and potentially assert a variety of claims for current configurations, alternate configurations, and potential future configurations too.
Yes.
So another hot area in consumer medical devices is the Oura Ring ITC investigation. You're probably familiar with Oura Rings. They're smart wearable platform that can measure lots of health data based on wearing those rings. They do utilize machine learning algorithms for measuring sleep with the devices. In the ITC proceeding, the asserted patents, however, focused on hardware and sensors, but not machine learning algorithms. Aura does have patents on machine learning algorithms and utilizing those techniques. This is one example of one of those claims that were not asserted in the litigation. Instead, like I said, they've focused on their smart ring design, internal and external component arrangements, sensor integrations, and manufacturing methods in trying to enforce their patents against competitors. The commercial value in the rings, however, seems to be increasingly come from the software and the predictive analytics that the rings and wearables are capable of providing to a user. And so while these cases have not presented how the machine learning algorithms can be asserted against another party, I think that's something we should look for going down the line. And perhaps that was a strategic call on Aura's part to not assert those patents at this time. Maybe they saw them as vulnerable to a 101 attack and chose to bring different claims instead. There are many in the industry moving towards there are many in the industry, especially in this ring space, many different competitors. And going forward, I think we should look for additional issues to come up in this litigation about the use of biometric data sets, AI-powered wellness insights, and fights over health prediction using these instruments. And they'll likely present us with challenges related to the machine learning and potentially AI-driven insights that the devices are becoming more and more capable of. There's plenty of other Intellectual property related disputes to come with these as well, not just the patent right issues over AI powered health insights, but I think we're increasingly going to see some potential trade secret litigation involving proprietary machine learning models. There might be more disputes about the ownership of biometric data sets for model training, and also challenges likely to arise related to the accuracy or regulatory status of these AI generated health predictions. As these wearables become more and more a part of everyone's, the intellectual property disputes are likely to heat up even more on these. Okay, so Prateek, let's move on now to some other challenges that we're seeing in enforcing medtech and AI-related patent claims.
Will do. First, I do want to flag that Apple cases, if I was saying that courts and juries are giving way to the patient monitoring limitations in the preamble. And I want to clarify that my point is more, we think juries may be given that kind of weight even if the courts don't instruct them to, because the terms are so plain compared to another term like, say, system. I hope that answers the question.
Great. So going into patent eligibility, then just a quick primer for a quick refresher on patent eligibility 101s here. So under the Supreme Court precedent, to determine whether an invention is patent eligible under 35 USC 101, it should fall within the statutory categories of a process, machine, manufacture, or composition of matter. There are judicial exceptions to patent eligibility that include an abstract idea, law of nature, or natural phenomenon. And the Supreme Court's Alice Mayo framework, which is summarized here on the slide, helps courts determine whether something is patent eligible or patent ineligible. First, there's a two-step process, and first they look at whether the claims are directed to a patent ineligible concept, a law of nature, natural phenomenon, or abstract idea. If they're not directed to one of those exceptions, then they're considered patent eligible. If they are directed to one of those patent eligible concepts, then the court proceeds to step 2 and looks at whether the claims focus on an inventive concept that is not well understood, routine, or conventional. Something that transforms the abstract idea or law of nature into a patent eligible application. Now, in computer implemented medical device cases, preemption is relevant because the core concept behind Section 101's judicial exceptions is preventing patents from monopolizing fundamental tools of science and technology. When we're dealing with healthcare and medical devices, those things are almost certainly arising in terms of the benefits of the invention and how they're working. And so courts will increasingly look at whether a claim would effectively preempt all or substantially all practical uses of the underlying claimed concept. A claim that broadly covers a correlation, for example, between a person's data and a medical condition could raise preemption concerns just like that, which there may be a concern from a court that it could block others from using that medical relationship. In contrast, claims tied to a specific technological implementation, for example, a sensor configuration, signal processing technique, device architecture, or a method of controlling a therapeutic device, those might be less likely to be viewed as impermissibly preemptive. So let's take a look at some recent cases involving these issues and how the courts are grappling with them.
Thank you. So one of the most helpful recent cases on this issue is the recent Federal Circuit decision in 2025, Presentive Analytics v. Fox Court. The holding that claims do no more than apply established methods of machine learning to a new data environment are not patent eligible. That's a holding that has appeared in a few medtech AI cases recently as well. So in that case itself, we know that the technology was focused on broadcaster programming. So it focused on optimizing schedules of live events and broadcaster programming within certain markets using machine learning models trained on historical data. Note that the claim set here only recited a computer-implemented method with several process steps, some of which interacted with the bare recitation of a machine learning model. And then the specification then had very broad definitions of the possible machine learning models, explaining that it could constitute any suitable machine learning technique, including a gradient boosted random forest, a regression, a neural network, a decision tree, and so forth. Ultimately, the court found that these claims were not eligible under 101 for several reasons. For the step one analysis, i.e., that it was directed to an abstract idea, it noted that the patents did not claim a specific way to improve on machine learning algorithms. And then further, the specification also conceded that network executives already use some of these parameters in making their decisions. So preemption concerns became a big concern here. In addition, when moved on to step two, it found that there was no inventive concept that Recentive could point to, because all Recentive identified was, again, the use of machine learning to aid these network executives in making their decisions. But ultimately there, a technology that was practically improving their decision making was still only making it move faster, and it wasn't a patentable distinction. It was not a patentable invention. So that's a very helpful case that will show up in several medtech devices. Then we can move.
All right, now we're going to go back in time a little bit to the CardioNet versus InfoBionic case. And this involved cardiac monitoring technologies. The claims were directed to a device for detecting and reporting the presence of atrial fibrillation or atrial flutter. They accomplished that by detecting various heart-related data, so a beat-by-beat timing of cardiac activity, detecting premature ventricular beats or irregular beats, different from a normal heart rhythm, and then determining the relevance of that beat-to-beat timing to potential atrial fibrillation or atrial flutter. And that took into account the variability of the beat-to-beat timing caused by premature ventricular beats. So CardioNet asserted its patent on this technology against InfoBionic. And InfoBionic immediately brought a motion to dismiss, a Rule 12 motion based on Section 101, arguing that the claims were patent ineligible. The district court agreed with that and dismissed the case from the start. CardioNet appealed that decision to the Federal Circuit, and the Federal Circuit reversed. They found that the defendant had not proven at that early stage in the litigation that the claims were directed to computerized cardiac monitoring, simply computerized cardiac monitoring systems, but were instead more likely patent eligible under Section 101 as being directed to specific technological improvements in heart monitoring technologies, not merely abstract ideas. So a takeaway here from this CardioNet case that seems to be very foundational in terms of moving forward, and we're seeing in other examples too, is that claims that recite a specific technological improvement in how a medical monitoring device processes physiological data is more likely to be patent eligible than claims that are merely directed to analysis of data and reporting of results. So on this case has continued since that positive Federal Circuit decision for CardioNet. The parties litigated for 2 more years after the decision. And InfoBionic continued to bring motions under Section 101 throughout the litigation, including several motions for summary judgment on Section 101, including renewed motions. But ultimately, the court never made a final decision on that issue because the parties dismissed the case and presumably settled it before any ruling on the pending summary judgment motion. So this is an example of how patent owners, and particularly patent owners in the medtech space may be likely to face very vigorous, early, and serial challenges to the patentability of their inventions under Section 101 and need to be prepared from the start to face those challenges head on because they're so likely to appear early and repeatedly. The next case we wanted to talk through today was Aon versus Zesty AI. And this case involved claims reciting a specific use of machine learning to solve a technical problem. Aon's machine learning patents, they evaluated property risk using aerial images of properties. And their claims used a specific arrangement between independently trained machine learning classifiers to analyze those aerial images and the data associated with them to identify various risks associated with the property. Aon sued Zesty in the District of Delaware, and similar to what we saw in the previous cases, Zesty brought an early motion to dismiss based on Section 101. The court concluded that Zesty had not shown at the pleading stage the claims were directed to an abstract idea under Alice Step 1 here too. Now, how was Aon able to overcome that early 101 motion? It persuaded the court that Aon, that first, there were alternative machine learning approaches to achieve the same result, to evaluate risks based on aerial images. And so their claims were specific to Aon's particular computer architecture and processing approach rather than the broader abstract idea of simply looking at aerial imagery to estimate risk. Now, this is not, obviously not medtech, a medtech case, but it is important to look at it in terms of how medical device litigators can utilize this moving forward as they're trying to hold up the eligibility of their claims as well. So this is a useful analogy where in medical device cases, the claims may recite a specific arrangement or algorithm, sensors, or classifiers that should improve diagnostic or monitoring performance. And the court's going to very much look at the preemption effect and say, are there alternative technological implementations possible that could be used other than what's recited in these claims? If there are, that may support overcoming that 101 motion and keeping the claims alive to fight another day. All right, so a quick summary here. Some things that are likely to be abstract, potentially likely to be challenged as an abstract idea. Claims directed to processes that anyone can perform without a computer. Claimed processes that doctors already perform. Inventive concept issues. Simply improving speed or efficiency of a pre-existing practice or technique may not rise to the level of an inventive concept depending on what's claimed. There may be no inventive concept if there's simply a claim directed to the bare use of training of machine learning techniques or training a system. Let's look at some more cases here. The next one is Polar Electro versus Sunto. And Polar Electro's technology relates to personalized heart rate monitor technology. And it uses regression equations to calibrate the relationship between heart rate and an individual's energy consumption. In that case, they're asserting claims, including Claim 5, which was directed to a method for assessing a person's energy consumption during exercise. And that method comprised measuring the person's heart rate information during exercise, also obtaining an energy consumption reference value, which could be maximal oxygen uptake, and assessing the person's energy consumption, wherein the energy consumption is substantially linear dependent on the heart rate parameter. The claim limitation that really was the linchpin here in the 101 analysis was measuring the person's heart rate information during exercise. The measuring the heart rate was simply something someone can take using a finger. They can do it manually. It does not require a device, something anyone can do while they're exercising. So the District of Utah analyzed the patent eligibility of these claims on a motion for summary judgment. It was not a motion to dismiss, but it was a very early motion for summary judgment before substantial discovery, before expert reports or things like that could be considered. And the court concluded that these claims were directed to an abstract idea involving simply collecting physiological data, applying mathematical relationships to the data, and generating an estimate of caloric expenditure or exercise intensity. The claims did not recite a specific technological improvement to the monitoring device itself, but instead simply claimed the result of analyzing the physiological information, giving that energy consumption output. And so here in this case, in the polar electro case, unlike the CardioNet case, where those claims improved the operation of a cardiac monitoring device, the polar claims were viewed as using conventional monitoring technology to perform data analysis and calculation, something that someone could do using paper, using known equations. And so the court treated the invention as simply an improved algorithm for interpreting data, not an improvement in the underlying technology used to collect or process that data. Prateek, do you want to tell us about the dental monitoring case?
Will do. So in this case, this is a case in dental imaging technology. It's one of three that we will cover in the next few minutes. So here between dental monitoring and online technology, this is a case that an order that came out in Northern District of California, 2024, on a motion for summary judgment of 101 invalidity, which was granted. The technology here concerns evaluating the patient's dental arch to help orthodontists make aligners. For example, these are the kind of products that Invisalign are. And in fact, Align Technology is the maker of Invisalign. Now, earlier on, it used to be that patients had to physically go to the orthodontist so that the orthodontist could make a qualitative assessment of the teeth position and decide how to make their next aligner. That's a lot more time than most people didn't have. And surprisingly, more modern technology has allowed the use of smartphones and other photography for the patient to transmit images of their dental arch to the orthodontist for that same evaluation. Now, the claim at issue, next slide, please. The claim at issue recites a method for acquiring an image of a dental arch, and it analyzes the analysis image of that dental arch by means of a deep learning device trained by means of a learning base. Next slide, please. Ultimately, it only recites specifically the bare usage of a deep learning device without specifying anything further. The court ultimately found that this was an abstract idea, which pointed just to the abstract idea of collecting information, analyzing it, and displaying certain results. This claim ultimately was only a common practice long performed by dental practitioners, and in fact, the specification conceded as such according to the court order. The court order pointed to a section in the background where the specification admitted that orthodontists conventionally do these kinds of assessments already. As you see up here, this assessment is conventionally performed by an orthodontist, which requires the patient to transmit these images, even to make an appointment. And then further, the court found that this failed step 2, lack of an inventive concept, because it didn't find any, sorry, this court found it was still an abstract idea because it didn't find a technological improvement in the use of AI techniques. The very subtle deep learning device limitation that we discussed earlier did not tell us more than that it was using deep learning device. And then the specification didn't provide any further guidance other than that the deep learning device could be any of a subset of well-known options, for example, several specific neural networks. Finding that it was directed to an abstract idea, the court then also moved on and decided that there was no inventive concept. The plaintiff, next slide. The plaintiff had identified concrete benefits, stuff including greater speed, greater ease, and the ability to make a quantitative measurement of a separation between the aligner and the teeth, as opposed to orthodontists having to make qualitative inspections as they would have had to do earlier. But even these were not inventive concepts in the court's eyes. As established in prior case law, improved speed or efficiency inherent in applying the idea on a computer did not make these claims eligible. And furthermore, the ability to make a formally qualitative application, now quantitative, by applying the abstract idea on a computer did not make the claims patent eligible. In other words, even though using AI made these practically better and practically smoother, that use of AI was not in itself a patentable invention. The plaintiff also tried to argue that how the deep learning device was trained was an inventive concept, making the point that the general deep learning devices that had asserted in the specification were just off the shelf and were not already trained for capturing dental imaging data. But the court also found that the claimed method of training only described how a generic deep learning device would be applied or limited. It wasn't an improvement in how deep learning devices are trained, period. So ultimately, the court rejected these on summary judgment. It granted summary judgment that these were invalid under 101. And an important takeaway here, something that's interesting, is that dental monitoring would have been better off developing in the specification and the record an explanation of why dentists and orthodontists could not already perform what was in the claim terms. Either that or they could rewrite the claim terms to get at a process that dentists and orthodontists already could not perform, because making it more efficient didn't help, making it quantitative did not help, even if it was a huge practical improvement. Now we have two more dental cases which also concern 101, except that these actually satisfy the 101 requirements. First of all, we have Overjet v. BDA Health in the District of Massachusetts in this past year. And then we have Osseoimaging Imaging versus Dentsply Sirona, the Eastern District of New York, also from this past year. So, thank you. Overjet concerned 2D dental imaging technology using what's known as a segmentation approach to scan X-rays and diagnose for pathologies. Note that this approach, the segmentation approach, outlines exactly where pathologies exist, which is in contrast to a prior bounded box approach. Now, the patent at issue identified a unique technical problem on the next slide, where when you're trying to measure oral structures on a patient using X-rays, you'll know that the patient has to move them the X-ray in some form, whether through breathing or other forms of motion. So measuring the projection of the X-ray on to the final screen, measuring the X-ray results you get, requires some calibration because otherwise it's not a one-to-one ratio. Usually, doctors had to use external object for calibration, but Overjet devised a technical solution which relied on using the patient's unique anatomical oral structure as internal calibration objects without the need for an external calibration object. This technical solution implemented machine learning technology, and the claims, in fact, captured this technology. So the claims recited a data process system using 3 machine learning algorithms on the next slide. One was a machine learning algorithm directed towards a segmenter, another being directed towards an object detector, and then the third was being directed toward a selector. So all in all, we have one machine learning algorithm for segmenting and one for object for detecting teeth objects, both of which predict masks and points of the oral structure. And then you have a third machine learning algorithm, which eventually helps calculate the calibrated measurement used in ratios and the image metadata. The court ultimately found on motion to dismiss that this was more than a bare recital of using common machine learning techniques. It is in fact similar to the recent A&E case, and that is using specific multiple technologies, specific multiple machine learning technologies as well. It's obviously on its way to technical improvement to the process, and the specification never conceded that this was the process doctors already did, and in fact explained that T could not ordinarily be imaged without an external calibration object. The next case is Osseo Imaging v. Dentsply Sirona, also from the past year. This was also a case decided on motion to dismiss ground, and it found that it refused to dismiss the litigation on one-on-one invalidity grounds. Here we have 3D dental imaging technology and technical problem. This one here, when we want a 3D scan of a tooth, usually dental applications need to rely on tomography or sectional radiography techniques with scan and X-ray beams. But this lacks the kind of 3D internal densitometry data that's already used in other aspects such as bone scans. So the patent owner here sought to implement that kind of densitometry data to teeth, and it provided a unique technical solution, which is a computer-controlled X-ray system that can also process the scan data to generate a patient-specific tomographic densitometry model. Like in Overjet, excuse me, that's captured in its claim. And again, this is an example where the patent owner identified a unique technical problem and a solution which dentists were not already able to perform. They successfully characterized that problem and then offered a unique technical solution. So, Emily, I think we can go on to the next slide. And that's just recapitulating what I'm saying. Thank you. And I think we can move on to Progenics now. Thank you.
Excellent. Okay, so Progenics Medical Imaging versus MIM Software is the next case. This was a case filed in the District of Massachusetts, and the decisions from 2025. Progenics Pharmaceuticals and had technology related to medical image analysis, and it addressed the specific problems in interpreting anatomical and functional medical images, and how to utilize those together to create more accurate and consistent cancer diagnostic and treatment planning, treatment plans. So here, the claims were directed to a network-based system for generating a disease risk map. And this is just part of the claims, but it involved an entire system, the processor, a memory with instructions for the processor to perform these particular steps. And the crux of the invention in the 101 analysis here was about creation of a 3D image of the one or more regions of risk of cancer or risk of recurrence of cancer overlaid on one or more medical images, wherein the 3D image compromises geographic identification of one or more specific tissue regions overlaid on one or more medical images. Well, physicians had traditionally received separate anatomical and functional scans, and they had to put those together, look at them separately, and then put them together to try to figure out from the different types of scans, the full picture of a cancer risk. The patents from Progenics were directed to the automated creation of a risk map using overlays of medical images, CT, PET scans, SPECT scans, including geographic identification of cancer risk regions. Those overlaid risk maps were improved from the traditional method of simply analyzing different medical scans and separately determining cancer area risks based on those visual inspections and evaluations. The bare recitation of machine learning alone to do that, to identify machine cancer risk, would likely not be an inventive concept. But here, the court found that MIM had failed to prove that the claims were invalid under Section 101 on a motion to dismiss. They said that Progenics had plausibly alleged in their complaint that the claimed inventions improved the functioning of medical imaging systems and image analysis technology itself, not merely the abstract idea of analyzing the information. And so the court concluded that the claims were patent eligible, denied the motion to dismiss, and the litigation proceeded. So a couple takeaways here. Prateek was talking about how patent specifications described the benefits of the inventions and distinguished them from abstract ideas. And here too, there was the benefit of having a complaint, which alleged in the complaint itself the differences between the claim techniques and the traditional manual processes, explaining how the claims were directed to something more than simply machine learning alone. They were improved ways for addressing specific problems, designed to improve accuracy and consistency, and they laid out the specific steps for doing that. And so why this matters moving forward for medical device and specifically imaging cases is that patents, it's important to emphasize in the complaint, and then again on a motion to dismiss if you face one in an imaging case, that the patents are directed to how medical images are processed, combined, segmented, visualized, or presented to clinicians, rather than focusing on the medical significance of the resulting information. And the complaint here and the court emphasized that addressing technical shortcomings in medical image analysis workflows, rather than claiming the underlying diagnostic judgments themselves, judgments that doctors and other professionals could make, was the linchpin for enabling these claims to continue past a motion under 101. All right, so that concludes a large section on patent eligibility. Obviously, AI-related claims, machine learning claims are going to be subject to significant scrutiny under Section 101 for their patent eligibility, and a large area that's coming up, a lot of motion practice. Many appeals to the federal circuit have arisen on these issues, and I think we're likely to see continued and ongoing scrutiny of patents and challenges to patents on the eligibility grounds. So let's move forward a little bit and talk about some challenges to patents based on obviousness in the medtech and AI space. The first one we'll cover is the AliveCor versus Apple case. You may recognize this one. It involves systems and methods for measuring and analyzing physiological data to detect cardiac arrhythmias. And you have the Apple device on the left showing how the Apple Watch and iPhone were providing that data, and you have on the right Cardia or AliveCor's technology where you had to put your fingers on those little pads to get the EKG reading on your phone. So in this case, again, the technology was about the cardiac monitoring using ECG and PPG data to detect arrhythmias. And some of the dependent claims here specifically recited usage of machine learning. So if we look at, for example, Claim 7, it recited an earlier method of Claim 1, further comprising determining a presence of said arrhythmia using a machine learning algorithm. So that pretty close to a bare recitation of using machine learning algorithm as you can get in a claim. And that was subject to the subject of the litigation, and a couple references that were asserted against that claim that involved broader disclosures of who an earlier reference from 1997 that discussed the detection of arrhythmias using ECG data. Lee, a 2012 reference, discussed using a machine learning algorithm with multiple data inputs. And putting those together, a court found that a person of ordinary skill in the art had both an interest and had a likelihood of success in adapting the machine learning to various biomedical applications, including the claimed alive core method of using machine learning to accomplish the goal of detecting arrhythmias. Before we move on there, this case shows that the combination of sensors and analytics may be increasingly vulnerable to these obviousness challenges. It shows us that applying conventional machine learning techniques to known physiological signals for a known diagnostic purpose is likely to be obvious unless the patent itself is identifying a specific technological innovation or a specific use of AI with a device implementation establishing a new way of doing those. It'll be important for litigants to distinguish, including potentially even in their complaint, how their technologies using sensors improve over what's been disclosed before. They're not simply a routine plug and play of we're going to use AI to do X, Y, and Z. And the Federal Circuit affirmed that decision, finding these claims were obvious.
And that takes us to the final case in this obviousness module, which is the PTAB version of the Align Technology versus Dental Monitoring dispute. You may remember from a few minutes ago, we were discussing the case over Invisalign and the claims that barely recited the deep learning device trained on a learning base. These are similar claims from a different patent between the same parties. And here, the PTAB was considering the petitioner argument that a combination of two prior references, Sala and Carrier, and a deep learning device disclosed by Manini taught the inventions in the claim. Next slide, please. The patent owner, however, argued that it tried to break up that combination by arguing that Manini's deep learning device could only be trained on contour data to identify an image. That is, it could not be trained on a learning base which included historical images. And this mattered, according to the patent owner, but the patent owner's specification indicated that his own learning base comprised more than 100,000 historical images of dental arches, all annotated with information for training. But unfortunately for the patent owner, the board did not agree with the patent owner there because the claim itself only recited a deep learning device trained by use of a learning base. And that is like petitioner only needed to show that this combination taught a deep learning device capable of being trained by a learning base rather than one that could be trained on contour data as the patent owner wanted. So this here ends up being another example of how the bare recital of a machine learning element or usage of a machine learning technique renders these claims vulnerable even in the PTAB for 103 issues, not just 101. Next slide. That here is a summary that one of the key takeaways being that reciting the bare usage of machine learning techniques and biomedical applications renders you vulnerable to prior art that teaches that same machine learning in other biomedical applications.
Thanks, Prateek. All right, let's turn to some issues that are coming up with AI in discovery, in litigation itself. And we'll start with challenges in producing training data during discovery and litigation. Prateek, can you tell us about what happened in the OpenAI ChatGPT litigation?
Yes. So this order took place last year as well. And for overall purposes, this is the dispute between the authors and the copyright holders who sued OpenAI entities for copyright infringement. This dispute ended up reducing to whether OpenAI trained one of its models using data sets that contained pirated copyright books and web content. As part of this litigation, the plaintiffs asked OpenAI to produce this English Golang dataset, which is a very large training dataset that was allegedly used to train its models. Next slide. So this dispute was governed by a training data protocol, which is separate from any sort of source code order or any other discovery order. And most importantly, the training data protocol did not mandate as a baseline that OpenAI turn over all of its training data sets in native form. Instead, OpenAI and plaintiffs had the option of mediating inspection access through a controlled environment that was oftentimes remote. And that worked for some training set data, but for particularly large training sets like the Golang data, this ended up failing because the remote setup was impractically slow and plaintiff was having trouble actually using this data set. So plaintiff asked for a native production on this, and OpenAI opposed, largely on grounds that the dataset was too large and sensitive, and also reflected proprietary information and how it was processed. Both of them took this matter to the magistrate judge, but in the end, he compelled OpenAI to produce that dataset. Next slide. Like, it's too large, too sensitive to export easily, but ultimately the court rejected all of that. It didn't have the parties meet and confer to handle logistical and security issues, but ultimately that kind of defense that the data sets are very large, there's not really a defense to producing your training data sets. And there becomes a risk that parties may start asking in any AI case for production of training data sets in native formats so that they can investigate whether they contain documents that would be relevant to knowledge or other willfulness cases. Next slide, please.
All right. Thanks, Prateek, for that update. One other topic we'll cover here towards the end are challenges in expert witness usage of AI, which is we're seeing increasing case law and opinions coming out on that as well. One case is Conservation Foundation versus Shell Oil, and that was from the District of Connecticut this year. In this case, Conservation Foundation's expert used ChatGPT to help call and analyze a document production into subsets for their further analysis. The expert did not review the full document production, and how, in many cases, how could they when there's tens and sometimes hundreds of thousands of documents produced? But the expert used those to confirm that whether there were additional documents. The court ordered Conservation to respond to interrogatories and RFPs that called for the disclosure of any artificial intelligence prompts and or queries used in the course of producing the expert witnesses' reports. Now here, the parties had an agreement, already come to an agreement on expert discovery that expert notes, drafts, and communications with counsel were protected work product and would not be the subject of discovery. But the court found that conservation experts' use of ChatGPT was not covered by that agreement as a note or a draft or a communication, and thus had to be produced. And so this is kind of a warning for people moving forward, looking at experts and how they're going to be working on your cases, and what they're going to have to turn over, is that even an expert's work on using AI, their ChatGPT log, what the outputs that come from their ChatGPT may need to be preserved, they may need to be produced, and that's something that litigators and clients should be looking to potentially have an agreement on with opposing counsel before those issues arise. A similar issue came up in the Coles versus Ellison case in the District of Minnesota last year. There, it was found in early motion practice involving a preliminary injunction that one of the state's expert witnesses had accidentally cited a fake AI-generated source. And Ultimately, the court ended up striking the entire declaration as unreliable because of that fake citation. The court also discussed expert and also attorney obligations under Rule 11 to the court, and was cautioned both experts and attorneys to not abdicate their independent judgment and critical thinking skills in favor of a ready-made AI-generated answer. So another cautionary tale here.
A third cautionary tale concerns Concord Music Group versus a small AI company known as Anthropic, where here they were already in litigation over a different matter, but then Anthropic submitted an expert declaration, which also ended up including an AI hallucinated citation. Anthropic eventually explained to the council that they had used cloud to reformat at least three of the already existing citations, and as part of this reformatting, they accidentally generated a fictitious article name with inaccurate authors for the citation at issue. But it came out in investigation that the original citation did point to an existing article properly linked to which is human found. So the court decided this was not a case where their attorneys had abdicated independent judgment and critical thinking skills in favor of AI-generated answers. Nevertheless, it still struck the relevant paragraph from the expert declaration as unreliable. So that still remains a cautionary tale. No matter how strong the explanation is, you're going to run the risk of losing parts of the expert declaration. And that takes us to the last case here, which is Ferlito v. Harbor Freight Tools. This here is a case where an expert used ChatGPT in what seems to be a proper way. Specifically, the plaintiff expert was opining that a mall was defectively designed, leading to the access splitting from the axe shaft while the axe was being swung. After completing the report, the expert used ChatGPT to ask about the best way to secure an access to a handle, and ChatGPT actually produced a response consistent with the already existing opinion. Although defendants challenged this use of AI, the court found little risk that the AI had actually impaired the expert's judgment and testimony, so it did not strike the report at all. So that brings us to a takeaway where it's probably okay to use these for experts, as long as you keep track of when you use the expert, when you use the AI sources, and as long as you generate your own opinions first.
All right, thanks, Prateek. A few just summarizing takeaways along with what Prateek said. Confirm whether your experts are using AI to draft declarations. Confirm that they have already exercised their independent judgment and thinking skills in forming their opinions before perhaps they test them. Be prepared to produce prompts used in generating expert reports and declarations, and be aware of AI hallucinations that may creep in regarding cases and other sources that could lead to striking key parts of expert declarations necessary in cases including patent litigation. So thank you very much for attending our CLE today on AI and medtech enforcement and litigation. We appreciate the opportunity to discuss some of these emerging litigation risks and emerging trends involving artificial intelligence and medical technologies. Please feel free to reach out to Prateek or I with any questions, or if we can be of assistance in the future. Thank you, everyone.
Yes, thank you so much, Emily, Prateek. Very informative, great summary of the case law and a number of topics that are relevant here. So, yeah, very educational and very useful here. We did receive, I think, one question from the audience. I think this is kind of going back to the beginning of the material, the talking about, I think it was the Apple ITC case. And specifically, I believe this is the Massimo versus Apple case, if we're talking correctly here. It's the question is there any impact about Apple having sought and received CBP approval on some of their redesigned devices? And so the question is does that open the door for other avenues to get around ITC exclusion orders? So maybe if you can kind of that question makes sense, kind of set us up to a possible answer about these ITC exclusion orders.
Thank you. So in the research we were doing, we didn't come across any mention of the CBP approval, but our research and the orders we consider were more from a claim construction point of view regardless. So I appreciate that issue being flagged. I think that's something that would come up in a different posture.
Okay, very good, very good.
Thank you.
And then maybe just one last comment. I know there was a lot of discussion of Section 101, kind of both pros and cons and different ways in which some of these cases have come up. I mean, do you think, curious, does the medical nature of a lot of these inventions, does it help or hurt the eligibility questions? And kind of what strategies have you seen, especially when it's something that's health related, improving people's ultimate health and as a treatment. What are ways in which that you think that the litigation can cast patents favorably or unfavorably, depending on which side you're on?
Absolutely. I mean, I think, the medical aspect, it can be helpful or it can be a challenge. And oftentimes it depends on how you're presenting it. And from the start, presenting it in your complaint is critical to trying to get past and dissuade your opposing party from bringing those 101 motions. So I think it at all steps, it's really looking at how can you frame the issue for the court. So always framing the issue in terms of how you're improving processes, how your system is different or improved system. And I think it's important to emphasize the benefits that these medical devices and technologies are bringing to patients, but also distinguishing those benefits from what's actually claimed, so that the court doesn't get confused and think you're claiming and preempting other people from being able to provide appropriate treatment down the line. That's really, I think, critical, especially at the district court stage and an early motion stage.
I think I would add just one of the issues we flagged earlier in the presentation was running across a few specifications which pretty much conceded that they were describing a process that doctors and surgeons and other physiologists already performed, which is to say they had a product out there that made their job much easier, made it more efficient, made it more quantitative, but that kind of benefit itself wasn't enough to get something patentable.
Yeah,
That's
that
a good,
makes a lot of sense.
and it may be that including in your patent that doctors can do X, Y, and
Mm.
Z. They can take a pulse, they
Yeah.
can look at X-rays, but they can't combine this process with this view to come to this conclusion using this technique. I think it's really about how you frame it, and that's a
Mhm.
good point, Prateek. And so you can say what they can do, but also consider saying what doctors can't do right now on their own to help emphasize what the patented claims are really bringing to the space.
Yeah, makes sense.
Thank you.
All right. I don't see any other questions, so I think we'll call it a wrap for the presentation here today. So thank you again, Emily, Prateek. Very informative, and thank you all for joining. So we'll sign off. Have a
Thanks so
great day,
much.
everyone. Thank
Bye.
you.
Thank you.